What's going on, everybody? It is Saturday night, and welcome back into Let's Talk Live. If this is your first time here, this is Let's Talk Live, and a lot of people call me LTL. A lot of people call me other names, but it's nice to see everybody back here in the live chat, and we'll get into it tonight, as we just had a ruling in Karen Read's civil trial, and one of the claims has been dismissed. And I'm going to take you through kind of my interpretation of it. Again, I'm not a legal scholar, but I'll give you my breakdown of what I think is going on. And maybe you agree, maybe you don't agree. We can discuss it. And I want to actually go back and play some of the civil trial video as to what the plaintiffs, and the plaintiffs are the O'Keefes, of what their claim is. And we're going to see that in the legal document as well tonight too. So let's do this before we get into it, get into my presentation. I got a presentation tonight. We're going to play some video. We're going to go through the motion. And again, you can watch if you want to hang out, subscribe. If this is your first time over here, comment, chat, have some fun in the chat. We're going to relax and discuss this filing. So before we do that, let's go up in the chat. Anne is here. Nice to see you. Sharon says that's a great start to this sham. Absolutely. This is something that's going on. This is moving in the right direction. I like this. And, I've been saying on the last couple of streams that we've been talking about this, is that I feel, listen, we went through, 2 criminal trials. And I've said this, if the O'Keefes, the plaintiffs in this civil case, want to go forward, I believe, and it's my opinion, that they're getting their asses handed to them again. I think they are. And, I think I just don't see it. I think there's enough evidence there that's brought from the criminal trial. And again, this opens up everything where things were suppressed by Judge Bev before. We're going to see more in the civil trial. You get everything. So there's going to be more completed text messages. There's going to be more completed geofencing data. We're going to see all of that. We'll see the communications, the documents. It's all going to be there. So, I, as much as I hate to see Karen having to go through another trial to clear her name, but like I said in the beginning of the stream, it's a good start in the right direction. So Deborah's here. Thank you to be here. She says, what a great day it was outside. Beautiful here in New England. Beautiful here in the state of Massachusetts. I think it was like 72. And at one point it hit about 80 degrees today. So it was really nice. Teeny's here. Nice to see you. Hello. Melanie Lewis, family member, is here. Thank you for being here. I appreciate it. Let's see. James Jackson in the chat. Good to see you, James. So Karen Read is not playing games. What up, LTL? What up, James Jackson? I'm going to be at your show on the 24th of October up in Malden. Do me a favor, James. Drop your details about that and where people can get tickets. And I know that you're close to capacity. You said, I have my ticket. I'm going to be there to support JFK. I'm going to be there to support Nan, Mike, the Young Jerks, and everybody up there. And I'm excited to see what kind of, party they put together. I've done several parties in the Free Karen Read movement over the last couple of years. And I want to check out something different this year. So I'm going to go check out JFK, support my friend Nan, and have some fun. Lettuce is here. Thank you so much. I appreciate it. She says, the flannel looks so good on you. Like the colors. Thank you. Yeah, I'm trying to change it up. Tisha said she loves this channel. Thanks for being here. I appreciate it. And thank you for being a channel member. Thank you so much. Lauren, my good friend, Lauren DC, in the chat, hanging out. Nice to see you and support, Lauren. I love you to death. Thank you so much. Lynn says, hey, Karen is 1000% innocent, and the cops there are all dirty and corrupt. I completely agree. Ruthie's here. Nice to see you. Oh, look at this, Lauren. Yeah, that's right. I forgot. Lauren's going to join us at the JFK show as well, too. So we're going to have fun. And we can't forget Kevy Kev. As well. We're going to go out and support him as well, too. So it's going to be nice to see all you guys. Linda's here. Hello, Linda. How are you? Lauren's here hanging out. Good to see you. Another Lauren. She said, good evening, everyone. Haven't made it to an LTL live in a while. Well, hopefully you'll have some fun here. We're going to go through my interpretation of the document. Again, I'm not a legal scholar. I'm not I'm not a lawyer, but maybe we can get through it and you agree with my opinion or you don't. Diane's here. Hello, Brian and James Jackson. Nice to see you. All right, let's do this. So we had a blurb, literally a blurb on the screen about this. And the only one that I saw that was talking about this was Boston 7 News. And it's a very small article from yesterday. And it just basically says judge throws out part of the civil lawsuit against Karen Read. It's funny. I haven't seen anybody really talking about this at all. I haven't seen anybody talk about this or break this down. So I said, why not? Let's do this and we'll get it going and we'll talk about this. You know, one thing that we know is Karen Read is free from any criminal wrongdoing. She's civilly being sued right now. And another thing too is that, you know, we don't have justice for John O'Keefe. We don't have that. And hopefully that this civil trial will bring out more details into getting the truth. I mean, we know what happened. They know what happened inside that house. We know what happened. And that's why I said, since I've been talking about the civil trial, get ready. And what I mean by get ready is I hope that the O'Keefes and all of those players at 34 Fairview are ready, because Karen's team, I say we, Karen's team will have the access to your devices, to your phones, to those depositions, and you cannot lie, and you will not be protected anymore by a corrupt judge and a corrupt state that wants to suppress discovery and evidence. It will be all on the table this time around. All right, let's get into this here. Boston WHDH. The judge dismissed a claim involving negligent infliction of emotional distress, and we'll get into that tonight as we talk about this in the wrongful death lawsuit against Karen Read on Friday. All other claims in the suit will move forward. Read, 45, is being sued for what the O'Keefe family claims is extreme and outrageous conduct in the 2022 death of her boyfriend, and the O'Keefe's family filed a lawsuit after Read's first trial concluded as a mistrial this year. And what they're talking about, the extreme and outrageous conduct, is going to be one, Aiden Turtleboy Carney doing his journalistic duty to talk about this case, to put questions out there and talk about this and write about it and talk about it on his YouTube channel. That's what the O'Keefes are saying is this extreme and outrageous conduct. It was a journalist that was doing his journalistic duty to talk about a story, to expose what was going on. This shit happens all day in the news. That's what I don't understand, that the O'Keefes don't understand this. And I've been talking about this as well too, is that you would think that you sat in a courtroom for two criminal trials. You had basically the exposure of all of the people at 34 Fairview, which I love that in the first trial. That pulled back all the onion layers of all the people that were involved at 34 Fairview, all the corrupt law enforcement agents that were brought into this trial. In the first trial, we got that. We exposed who they were. But then in the second trial, what did we get to? We got to the data. We got to the facts. We got to the claims of Karen hitting John. And then we had the evidence from all the reconstruction from the defendants to show that Karen Read did not hit John O'Keefe, and John O'Keefe never made any contact with Karen Read's vehicle. We had Blue Paint Man on the DA side, threw some blue paint on, dressed up like John O'Keefe, acting like a clown, jumping in front of a car, literally throwing himself into a car to try to prove this point that Karen hit John. It just didn't play to the jury, and it didn't play to the public, because we knew all the bullshit that was going on. So, like I said, the first trial, you had the exposure of everybody at 34 Fairview, and then they really dug into the data. In the second one, and we exposed, and they exposed, I keep saying we, and they exposed the lack of education on the state side of their witnesses. Man Shannon, remember, got pummeled on the stand. And I just keep saying this in the civil trial. I just think, in my opinion, that the O'Keefes are going to get their asses handed to them a third time as well, too. So let's roll down here. It says O'Keefe family said, who also named the two Canton bars where the pair drank the night of the O'Keefe's death as defendants. It says Reed was back in court in September to try to get some of those counts dismissed. Reed's boyfriend, Boston police officer John O'Keefe, was found dead in the snow in front of a Canton home in January of 2022. Reed is accused of hitting and killing the 46-year-old and totally cleared of all those charges. She was acquitted on murder and manslaughter charges in the second high-profile trial in June. She was found guilty of operating under the influence. Her civil suit against her was filed in August of 2024. So again, a blurb on the screen, not being discussed, but we'll discuss it here. We'll discuss it here. Let's see. Jedi Jen says Blue Man Group was the best part of the trial. Yeah, to see that and watch that reenactment was beyond hilarious. Beyond hilarious. Lauren just saying, don't forget to hit and subscribe. All right, let's get into my presentation here. And then I want to go back and I want to play you the hearing, the part of the hearing the other day when the O'Keefes are making their assertion in this case. And they are the plaintiffs. They make their assertion as to what they say are the facts. What they are saying are the facts. And we're going to go through that. We're going to listen to it. And I'm going to talk about some of the hit points in this document as well, too. And again, I'm not a legal scholar. I'm not a legal analyst. I'm just going to give you my interpretation of what I think is going on here. You can agree. You can disagree. We can have that type of conversation. All right, so we look at the overview here. Massachusetts Superior Court Judge Daniel J. O'Shea has issued a major ruling in the civil lawsuit filed by the family of the Boston police officer John J.J. O'Keefe against Karen Reed in two Canton area bars, C.F. McCarthy's and the Waterfall Bar and Grill. This ruling addresses motions to dismiss filed by the defendant and determines which claims may proceed to trial. And that was really a long, in that hearing, the last part of it, the second part of that hearing is like 40 minutes, and that's really what they addressed. And basically, Judge O'Shea said, I'm not going to address it during this hearing, but I'll give you my ruling afterwards. So it is separate from the ongoing criminal case against Karen Reed and focuses entirely on the civil liability for the wrongful death and emotional distress related to the events on January 29, 2022. Thank you so much, Little Miss Reed. Little Miss Red Velvet, I love it. So just popping in to support you from the UK, a JFK long gamer. Love that. Thank you so much for being here. Appreciate that. Linda checking in. Hello. Good to see you. All right, let's move on here. So we look at who is involved. Who is involved? The plaintiffs. Keep this in mind. The plaintiffs, John and Margaret O'Keefe, that's JJ's parents. Paul O'Keefe, that's JJ's brother and personal representative of the estate. And then we have Kaylee Furbush, that is the niece and legal ward. So we have the defendants, Karen Reed, C.F. McCarthy's, and the Waterfall, which is CNC Hospitality LLC. That's probably that's the Waterfall Bar and Grill and the Waterfall Bar and Grill Limited. Okay, so we'll move on here. So we have the alleged allegations. Again, this is from the plaintiff. This is from the O'Keefes. This is from the O'Keefes. So keep this in mind. The O'Keefes are the plaintiff in the civil trial. So we have alcohol. This is what they're alleging. This is what actually they stated as facts in this claim. So alcohol over service. Reed allegedly consumes 9 drinks before 2 establishments, leaving with a blood alcohol content of 0.13 and 0.29. This is what the plaintiffs, the O'Keefes, are claiming. Fatal incident. We have the plaintiff's claim that Reed, while intoxicated, drove to 34 Fairview in Canton, struck JJ O'Keefe with her vehicle, and then fled. Then we have the aftermath. It is alleged that Reed returned to JJ's home, woke up his niece Kaylee around 4:30 a.m. and made statements such as, maybe I hit him, maybe a plow did. Well, maybe is just maybe. And it's all alleged. And it even says inside the civil case that Kaylee allegedly thought I looked up allegedly, and it says a claim or assertion that someone has done something illegal or wrong, typically without proof that this is the case. And he allegedly, and it says, and he allegedly that he alleged that he had been assaulted, to suppose or affirm to be the case. So that will be up to a judge and a jury to decide. So we have the cover-up allegations. And again, this is from the plaintiffs. This is from the O'Keefes. O'Keefes contend that Reed later pretended to comfort the family while removing or concealing evidence related to her vehicle. And then we have the public narrative. The complaint alleged that the Reed collaboration with blogger, and that's what's stated in the document. I say journalist. Aidan Carney, Turtle Boy, spread a false conspiracy narrative online, directing harassment towards witnesses and the O'Keefe family. All right, let's move on here. So basically what happened, actually, you know what I want to do before I do this? Let's pull up because I want to go over a couple points. And again, I'm not going to go over the whole complaint. Let me just move this over here so I can bring it up. And then I want to just pull out a couple of points. And then we're going to listen to the actual, what the O'Keefes are alleging. All right. So I don't know if you're going to be able to see this. Oh, I can make it bigger here. All right. So a couple of points that I wanted to bring out here. So we look at the background, and we're going to play the video from the civil hearing so we can actually hear what the O'Keefe's plaintiffs in this case are standing on. So and I want you to hear this first sentence. The following facts are drawn from the plaintiff's complaint and accept as true for purpose in this motion. So everything that they are listing under the background in this document is what they are claiming as fact. I just want everybody to understand that, what they are claiming as fact. So on January 28, 2022, Reed patronized C.F. McCarthy's at 8:51 p.m. through 10:29 p.m. She consumed several alcoholic drinks during that time frame. Reed then patronized the waterfall from 10:54 p.m. that night through 12:10 a.m. the next morning. She consumed 2 alcoholic drinks during that time frame. Her blood was drawn on January 29, 2022, and tested revealed that her blood alcohol content would have been between 0.13% and 0.29% after leaving the waterfall. Would have been. So woulda, shoulda, coulda, right? Joe says the O'Keefes are desperate. Yeah. Woulda, shoulda, coulda. That's the game we're playing now. Woulda, shoulda, coulda. Right? So it goes in, revealed that her blood alcohol content would have, here it is again, woulda, shoulda, coulda, between 0.13 and 0.29 after leaving the waterfall. During the time frame relevant to the instant lawsuit, Reed and JJ were dating in a dating relationship. JJ was with Reed that evening, and they had been arguing. After leaving the waterfall, Reed got into a motor vehicle with JJ and drove to the residence at 34 Fairview in Canton while intoxicated. So how do you fucking know that they were arguing? How do you know they were arguing when they left? How do you know that? Were you inside the car? Were you inside the SUV when it drove over to 34 Fairview? Again, woulda, shoulda, coulda. Maybe, I don't know, could have been, but they're stating this as facts. This is the facts that they are stating, that they are claiming what they think happened. After arriving at the residence, JJ exited Reed's vehicle. Reed then drove her vehicle and hit JJ. JJ was knocked to the ground, suffering serious injuries that ultimately led to his death. Well, we go back to the criminal trial. Guess what? It was factually proven that Karen Reed did not make any contact with John O'Keefe, and factually proven, scientifically proven, that Karen Reed did not strike John O'Keefe. So to me, that's going to be a big part of this and a big hang up. And they're going to need some expert witnesses to come in and try to prove this, in my opinion. I think they're going to have a hard time. So it says Reed fled the scene and drove to JJ's residence at 1 Meadows Avenue in Canton at approximately 4:30 a.m. On January 29, 2022. Reed woke up at JJ's niece, Kaylee, who lived with JJ. Reed began discussing JJ's death, and Kaylee then talked about striking him, and then with Kaylee, and then talked about striking him with her vehicle. Quote, Kaylee heard defendant Reed say, JJ never came home. Maybe I did something. Maybe a snowplow hit him. Maybe I hit him. Maybe I hit him. We were in an argument. Maybe he got hit by a plow. It's the maybe game. And then it says complaint paragraph 150. Reed also called multiple people between 4:30 a.m. and 5 a.m. on January 29, 2022, while in Kaylee's presence. At the time, Reed knew Kaylee was a vulnerable minor who had previously lost both parents and lived with JJ as her surrogate parent. I mean, I don't want to be rude, but I don't think that was probably the most forefront thing in Karen's mind at that time. I just don't think, personally, that's exactly what she was thinking about in that very moment. So how would you know that? It says Reed left JJ's residence at approximately 5:07 a.m. on January 29, 2022. She arrived at 34 Fairview at approximately 6:03 a.m. and discovered JJ buried in snow. JJ was pronounced dead at the hospital at 7:50 a.m. At relevant times after 7:50 a.m. on January 29, 2022, defendant Reed went to the grieving house of JJ, foreign comfort to JJ's family, and used the opportunity to, amongst other things, remove the offending weapon, her vehicle, and destroy relevant evidence. Okay. Oh, man. Subsequently, over the course of several years, Reed made memorable statements. She knowingly and deliberately changed her story and fabricated a conspiracy, knowing the same to be false. She publicly communicated this false narrative, therefore frustrating justice for JJ. Such false narrative caused the plaintiff's aggravated emotional distress complaint. Here's the thing. People talk about cases. People go out and discuss cases. You can have public discourse amongst people. You can. Even if you're a defendant, you can talk about it. It might not be as ill-advised by your lawyer, but you have every right to go out there and put yourself out and talk about your story. You have the right to do that. Again, it might not be advised by your attorneys, but you can. And the public talks about these things too. I mean, how many times do you see something like on court TV, a case that comes up and people just start to talk about it? And I just have this crazy feeling, this crazy thing that she says she publicly communicated this false narrative, therefore frustrating justice. Well, if it was a false narrative, then why did a jury in 2 trials not convict Karen and cleared her name in 2 trials? She ultimately was acquitted in the second trial. Where is the false narrative? And again, this is what the O'Keefes are saying. They're the plaintiffs in this case. This is what they're claiming as fact. I like this. 1-800-PSYCHO. Yes, and that's what I was talking about. Woulda, coulda, shoulda. The maybe isn't good enough. Exactly. Because you don't know for a fact, but you're stating it as a fact. Crazy. Okay. So let's get into, I wanted to scroll down here and talk about a little bit of, okay, right here. This is what I want to get into. So the negligent infliction in emotional distress. The defendants argue that none of the plaintiffs have actionable claims for neglect infliction of emotional distress because their allegations distress did not occur contemporaneously with the accident given the rise of JJ's death. This argument is inconsistent with the established Massachusetts gate law, and there's the case law. I'm not going to read through it. I'm just going to skip down because I want to get into, let's see. Thus, the family member is entitled to emotional distress damages when they are either a witness the decedent actual injury or came upon his injury promptly to after the injury. The plaintiffs alleged that that Reed discovered JJ's buried in the snow at approximately 6:03 a.m. on January 29, 2022, and he was then subsequently pronounced dead at a hospital at 7:50 that day. Margaret and John and Paul each favor that they learned of JJ's admission to the hospital immediately and came to JJ's body at the hospital shortly thereafter. Complaint in paragraphs, and there's attached paragraphs here. Against this backdrop, the complainant alleges sufficient facts that JJ's parents and brother arrived promptly at the hospital upon learning of JJ's death and thus have actionable claims for negligent infliction of emotional distress. Kaylee's negligent infliction of emotional distress claim stands on different footing. However, she alleges that she learned of JJ's death or injury when defendant Reed woke up Kaylee at approximately 4:30 a.m., January 29, 2022. Complaint in paragraph 147. Further, Kaylee alleges she heard defendant Reed say JJ never came home. Maybe I did something. Maybe a snowplow hit him. Maybe I hit him. Maybe I hit him. Were the argument, maybe he got hit by a snowplow. Let me ask you a question. Is it possible that someone was coached here? Now, I'm just asking a question. I'm alleging myself. But is it possible that someone was coached after the fact? And that's why we hear a lot of allege. Could someone have sat Kaylee down and said, well, maybe you heard this. Maybe you heard that. Maybe. We're hearing a lot of maybes. We are hearing a lot of maybes in this document, right? We're hearing a lot of alleged, right? Is it possible that happened? Could it be possible? Maybe. I don't know. Right? Lauren says if the O'Keefe started talking to Kaylee early enough, they could have planted a false memory. And we've heard that a lot in cases. We've heard that a lot in interrogations, false memories, where people basically get coached into not having anything to do with a case, but then they actually start to believe that they did do it, that they believe that they did a crime, they committed a crime. Lauren says, I don't ever recall hearing that Kaylee said that she said any of this until the civil case. Isn't that amazing? And it's sad, that you look at this, and in my opinion, we're just going to use children now to front a civil case. And I hope that the O'Keefes, and this is just my opinion, have some type of conscience here that they're not using this young lady that's clearly been through a lot in her life, and they're coaching her up to talk a bunch of bullshit in this civil case to back their claim. That would be absolutely disgusting. Absolutely disgusting. So it says, lastly, Kaylee states that as a result of Reed's conversations in her presence, she perceived the injuries caused to her guardian, Uncle JJ, and perceived the injury producing an event. To me, that doesn't sound like something that, a child would say. So taken together, the complaint does not allege that Kaylee learned of JJ's death injury at 4:30 a.m., but instead learned he may be injured at this time. There was no advertisement regarding when the circumstances under she first observed the deceased JJ, her adverment concerns her perceptions of JJ's injuries rather than her own observations. The case law cited by the parties addressed scenarios where a family member has observed another family member actually being injured or otherwise suffering shock after promptly encountering the injured family member. Kaylee cannot make this showing. Well, that's interesting. In making this assessment, the court acknowledges the following case law cites in the plaintiff's opposition. So it says the determination whether it should be liable for the injury sustained depends on the number of factors, such as where, when, and how the injury of the third party entered into the consciousness of that claimant, where what degree there is also familia, and other relationships between claimant and the third person. So I want to go down to a little bit more here. So therefore, the defendant's motions are denied as to Margaret and John, and Paul's claims for negligent infliction emotional distress is allowed as Kaylee's claim for negligent infliction of emotional distress. So let's just do this really quick. So Linda says the O'Keefe family was coached and brainwashed from day one by Jen. Completely agree. Completely agree. Remember, get your timeline. Remember, Peggy, you better write this down. Get your timeline straight. Remember? It's what they did. Let's get it down. Golden Mom, $5. Thank you so much for the support here on this Saturday night. She says, love your coverage. Research shows our memories can be so easily manipulated that in just 3 hours, you can be convinced and committed a crime as a teen. Wow. Yeah, you can be coached into stuff. False confessions. We've heard it. So this is the reckless infliction of emotional distress, and this has to do with the social media aspect of all of this, and Aiden's reporting in all of this, and we'll read through a little bit of this here. So the defendants argue that none of the plaintiffs have actionable claim for reckless infliction of emotional distress because there was no extreme and outrageous conduct directing them towards the result of severe harm. In context of such claim, content is extreme and outrageous. And if it goes that all possible bounds of decency in the regard of the atrocious and utterly intolerable in the civilized community, the standard of extreme and outrageous conduct is a high bar. Such conduct means that other than workday insults, just going to get my screen to go down here, workday insults, annoyances, and even threats are pretty oppressive. It means, for an example, in high order and reckless, ruthless, or debate malevolence that is simply intolerable. And it quotes a case law as well, too. The plaintiffs allege, again, we're alleging, that Reed developed a narrative surrounding JJ's death, which caused them to suffer emotional distress. In support of their opposition in the instant motions, they have produced a search warrant affidavit, which is the matter of public record that the court may consider assessing whether the complainant plausibility suggests an entitlement to relief. You know, I sit there and I look at all of this, and I want to kind of say, like, I don't know how I feel about this. I mean, you're either dumb, you're stupid. I don't know if I should feel sad or whatever. But I'm just sitting there and I'm going, you know, listen, you, as far as the O'Keefes, you know, you sat through 2 criminal trials that literally exposed people that you wanted to roll with, people that were present at 34 Fairview that night, people that know what happened to John O'Keefe at 34 Fairview that night. You know, police officers that were majorly corrupt. You saw, you know, missing video footage. You saw manipulated taillight. You saw the hiding of evidence. You saw poor evidence collection. You didn't see any type of interview. You didn't see any written documents as to things that were documented, except you saw timelines that were scripted and manufactured by people that were inside 34 Fairview. You saw a guy that's a homeowner that did not come out to help your son. Supposedly the dog didn't make any noise. Chloe didn't make any noise. Brian Albert didn't hear the dog bark. You know, and I can go on and on and on. And then you saw at the very end of trial 2, the reconstruction of the accident, the said accident. And it proved that your son was not hit or killed by Karen Reed. And you're still deciding to roll with these people at 34 Fairview. Wake up. Time to turn the tides here. I think I'd have a little bit more respect where they go, you know what? We believe Karen didn't do this. Now we need to start questioning the people at 34 Fairview. Now we need to start questioning the corrupt law enforcement agents and police officers that were involved in this case with the investigation. And I said this before, and I've been talking about it a lot on my lives in the last couple of weeks. If this was me and I died at 34 Fairview, the first thing my mom would do is drive over to 34 Fairview, knock on that door in the morning and say, we need to have a conversation here. I need to know what happened to my son. What did you see? What did you hear? No, but what you got was Jennifer McCabe right off the bat, creating the narrative, creating the story. That's exactly what you got. And you believed it and you fell for it. You fell for it. So it goes on to, according to the search warrant materials on January 22nd, 2024, Detective Lieutenant Brian Tully of Massachusetts State Police applied for a warrant to seize mobile devices captured of communication and cell phones used by Karen Read. Oh, and you goddamn right know that I have FOIA request that already, because if there is any body cam footage, I want to see it. I want to know what happened. And hopefully I'll get it. It might take me fucking 9 months, but I've already filed the FOIA request for it. He filed a return of the search warrant on January 24th, 2024. Tully submitted an affidavit in support of the search warrant application. The affidavit, I'll get this right, compromises 31 pages and discusses Read's communication regarding JJ's death. Maybe I'll FOIA request that as well, too. Maybe we want to see that document and see what's inside that document. Not sure if I'm going to get it, but maybe after this. No, I know. After this live tonight, I'm going to try to get that document, too. We want transparency. We want to know what says in these documents. Briefly stated by the affidavit, largely describes sections of a local blogger, Aidan Carney, who runs a series of social media websites under the name Turtle Boy. The affidavit states Carney posted articles on social media accounts that reflected personal attacks on civilian witnesses, members of their family, and friends. Well, he discussed the case. He did his journalism, and he exposed the truth. And there's nothing wrong with that. That is what the First Amendment is all about. Freedom of press. We have that right. I have that right tonight to be on this show with my camera and my microphone and to go over what I see here, and I can give you my opinion of it. Linda says, you're so right, Brian. They heard the same trial, witnesses, experts, and let me try this again. You're so right, Brian. They heard the same trial, witnesses, experts, we did, and they were blind by hate for Karen. I believe if someone confessed, they'd be disappointed it wasn't Karen. And Tully was everywhere. And thank you, Melanie. I appreciate that. Just say after David. After David. Okay. So we read on. All right. Where was I? The affidavit states that Carney posted articles on social media, reflected personal attacks. Okay. Carney identified several individuals who socialized with JJ Read, stated that they, not Read, were responsible for JJ's murder. You can have that opinion. You can have that opinion. And encouraged his social media followers to contact and harass these individuals. Additionally, the affidavit references contains comments Carney directed to the O'Keefe family. So let's see this. Quote, how much slack are we supposed to give you, O'Keefe family? The time period for grief, whatever that we were giving you, like we are not going after you because of your grief, that is expired. It expired because you're trying to send an innocent woman to jail for the rest of her life. I don't feel bad for you anymore. Well, that's his opinion. That's his opinion. Freedom of press. Plaintiff's opposition. So we have, per the affidavit, Read's communication with Carney through an intermediary, Natalie Berkschneider. I think I said that right. Berkschneider. Through the intermediary, Reed gave Carney information concerning her case, some of which potentially not available to the public, which Carney then used in social media postings. Reed had shared personal information and pictures of many civilian individuals whom Carney argued were responsible for JJ's death. You have every right as a person to give whatever information you want. That's part of your case. And again, it might not be advised by legal lawyers, but apparently her lawyers didn't have a problem. And she can get her story out and she can talk about it. It's just like going on. It's just like going on a show and talking about your case. It's like going up to those front steps that we heard time and time again after hearings, after trial. You know, the attorney speaking, Karen speaking. You have every right to do that. Okay, let's see. When applying the plausibility standards required by Rule 12, such actions are consistent with the plaintiff's averment that Reed developed a narrative surrounding JJ's death. Now, again, this is they're stating this as fact. This is what their whole basis of this part of the civil case is about. Carney unquestionably took extensive efforts in publicizing information regarding the charges against Reed, and the affidavit describes Reed acting in concert with some of those efforts. Notably, Carney stated that the time had expired for going after the O'Keefe family, and the O'Keefe family was involved in a cover-up regarding JJ's death. Taken as a whole and applying its plausibility standard, the complaint and the warrant affidavit set forward sufficient facts that extensive media attention perpetuated after JJ's death caused the plaintiff to suffer emotional stress. What? Because this was out in public and talked about? It was going to be talked about. That's what happens when a major case like this hits the airwaves. It's going to get talked about. People are going to have opinions. People are going to write about it. People are going to have shows about it. Of course, it's what we did here for the last 2 years. And you're allowed to do that. Primarily, the defendant's motion set forth generalized legal statements for extreme and outrageous conduct. As to substantive argument, Reed cites, and there's the case law here. Let's see. I'm going to go down the SJC, and let's see. The court acknowledges that Pele shares parallels to the dispute between individuals which escalate into allegedly harassing behaviors. However, given the extensive scope of media scrutiny and Reed's relationship with Carney, as alleged in the complaint and search warrant affidavit, the facts of this case would rise above those as issues Pele because of their public and persuasive nature. Well, how about all the shit that was thrown at Karen? About all the stuff that was put out there in the media about her? How about all the things that the anti-Karen said against Karen? You know, it's kind of like it's gonna get discussed on both sides. You know, that's what's gonna happen here. There's gonna be public discourse about this. Let's see. Pat's lover Bobby says, "I love your show. Thank you so much for hanging out here." Okay. So we move on. Claims asserted by Kaylee Furbish. The defendant argued that the complaint was not sufficient facts of Kaylee suffered emotional distress and that it does not describe which conduct applies to which claim. As discussed above, Kaylee's claim for negligent infliction of emotional distress must be dismissed for failure to state a viable claim. However, consistent with Margaret and John and Paul's claim, Kaylee was also plausibly distressed by the public and persuasive nature of Reed's alleged false narrative. Kaylee was also plausibly distressed by the public and persuasive nature of Reed's alleged false narrative. How about fucking dragging your kids into court and having them testify? How about that? How about that? How about that? How about you causing them the emotional distress to have them go through 2 trials and sit through this and talk? Let's do this. Let's just get back on topic here. If you're not going to be on topic here, you don't have to watch. You don't have to be here. You can unsubscribe. We're talking about the Karen Reed civil trial tonight. Karen Reed is free and clear of any wrongdoing in the criminal trials, but she's facing a civil claim right now. She's facing a civil trial, and we still don't have justice for John O'Keefe. So we'll move on. Kaylee's the only plaintiff who asserted a claim for intentional infliction of emotional distress. A claim for intentional infliction of emotional distress requires sufficient advertments that read intended to inflict emotional distress, or she knew or she could have known that emotional stress was likely result of her conduct. I don't know, man. Civil trials are crazy. Crazy. Seems a lot of things that are hard to prove. A lot of claims hard to prove. With reference to specific allegations of the complainant, Reed's motion states that Kaylee Furbish's presence is also not actionable conduct. This does not convey the full scope of what occurred during the early morning hours of January 29, 2022, in the manner alleged in the complainant. Instead, the complainant plausibly pleads that Reed made multiple distressing calls about JJ's physical condition, namely being struck by Reed's vehicle or a snowplow. Oh, interesting. We're going to drop that in there now. Karen 2.0 says not to mention the brainwashing they did to the kids. Exactly. I mean, you talk about emotional distress, losing two parents, losing a surrogate, and then all of a sudden you're going to put them through this. And it is, like Melanie said, exactly. And they're still doing it. They're using them in the civil trial. Ellie Woods says, hey, I know Kaylee's claim didn't have a leg to stand on. There's no legal basis at all. She didn't see anything, and she was not in close proximity of the event. Very true. And that's what I talked about. I feel, like I said, in my opinion, some coaching going on there. Can you just say these words? Can you say this? We'll use it in the civil claim. So let's see. Thus, based on Kaylee's vulnerability, and is Reed at the minimum knew or should have known that her conduct would cause Kaylee to suffer emotional distress. This plausibility supports the claim for intentional infliction of emotional distress. Therefore, the defendant's motion to dismiss are denied, as the arguments regarding sufficiency of Kaylee's claim. And therefore, the defendant's motion are allowed as neglect to infliction of emotional distress claim inserted by Kaylee and denied as their claim for reckless and or intentional infliction of emotional distress. Lots of emotions, lots of distress. The defendant's motion are denied in other respects. It's super sad. I mean, you're gonna make them relive this again, and they're probably gonna get called as witnesses in this fucking civil trial. These kids are never going to have a normal life. They haven't had any time to grieve through any of this. It's been one traumatic event after another, after another, after another, after another. Do you realize what that does when a young brain is still taking shape? When a young brain is still filtering and processing the world, what kind of impact that leaves on their brain? They're going to have to go through probably years, if they choose to do so, years of therapy, multiple years of therapy, probably therapy their whole entire life. And that's even if they want to do it. And then you have to look at what are the impacts of all this? God forbid they grow up and they become alcoholics or drug addicts or other horrible things. I don't want to see anything like that happen. I know you all don't want to see anything like that happen, but this is the impact that happens with trauma on the brain, especially the repeated trauma over and over and over again. And then you're putting this child out there again in this civil case that you're making one of your top points in this case. You're not allowing them to come down. You're not allowing them to process. You're not allowing them to grieve in a right way. Oh, let's just keep spinning it up. Let's keep spinning it up. And then, we're going to use Kaylee and put her up there as a witness and drag her into the civil case and, have to go through this all over again. And, again, I guess 2 to 3 years when we see an end result in this. It's crazy. Okay, so let's go back up to I'm going to pull up my screen again. So let me do this. And basically, we can go through what this is. So the court's ruling, Judge David J. O'Shea issued a memo and ordered in October 3rd, on October 3rd, 2025. The ruling denies most of the defense motion to dismiss, allowing the majority of the claim to proceed. Excuse me. Teresa says, money, the root is the root of all evil. Absolutely. Yeah, we've had Todd and Nan weigh in on this. You just got to go back and watch my live streams if this is your first time over here. We've talked about this. We have talked about this, but I'd love to get them in on this as well too. We'll probably do that. So claims that survived. Okay, wrongful death claim against Reed, C.F. McCarthy's in the Waterfall Bar and Grill. Negligent infliction and emotional distress for JJ's parents and brother, who arrived promptly at the hospital and viewed JJ shortly after his death. And you have the reckless and intentional infliction of emotional distress for all the plaintiffs, including Kaylee, and then the allegations of false social media narrative deemed plausibly extreme and outrageous, sufficient to move forward to discovery. So they're going to get discovery in that. Oh, man, I can't wait to see what kind of discovery comes out of that. Because what I always say, you better be ready for it, because you're going to be involved in too. And this is what I mean. The O'Keefes, the McCabe's, the McAlberts, Mass State Police, Canton police officers, first responders, it all comes in. It all comes in this time. Teresa, thank you so much for becoming a YouTube member. I appreciate that. Welcome to the family. Just like Lauren DC was saying, my moderator, my friend, member. Thank you so much for supporting LTL. And Jenny Jen says, hey, look, the quote is love. The love is money, is the root of all evil. And that is so true. So then we have the claims that were dismissed. Only Kaylee's negligent emotional distress claim was dismissed because she did not directly witness JJ's injury or death. So we move on. The legal reasoning here. Massachusetts allows emotional distress claims independent of wrongful death claims, citing, I think it's Chimio and Milford Kegg in 1982. A family may recover for distress if the trauma occurs while witnessing or shortly after encountering an injured relative under Dioconzi ski, a Stockdale. And in the court emphasized that Reed alleged post-incident conducted and participant in online harassment and could possibly meet the legal threshold for extreme and outrageous. And again, they're going to go into discovery hearing for that. Special consideration was given to Kaylee as vulnerable as a minor who had already lost both parents, making her particularly susceptible to emotional harm. And then you look at the social media component. The court cited a Massachusetts State Police search warrant affidavit from Detective Brian Tully describing communication between Reed and Turtle Boy via an intermediary. Thank you. Post alleged encounters, harassment of witness, and contained personal attacks against John O'Keefe's family. The judge noted that such extensive online conduct, if proven, could constitute reckless and or intentional infliction of emotional distress. So if we look at this chart, and I'm going to look over here because it's a little bit bigger, the civil case breakdown, the plaintiff's allegations versus the court rulings. Plaintiff's allegations. Karen Reed oversees C.F. McCarthy 7 drinks in the Waterfall Bar and Grill, 2 drinks, blood alcohol, estimate between 0.13 and 0.29. The court's ruling on October 3rd, the bars, McCarthy's and Waterfall, remain defendants. Wrongful death and emotional distress claims against them survived the dismissal. You have the fatal accident. Plaintiffs allege Reed struck JJ with her SUV while intoxicated at 34 Fairview Road. And you have the court's ruling on the 3rd was wrongful death claim remains intact against Reed and the bars. The aftermath, that's the plaintiff's allegations. Plaintiffs said Reed foreign comfort to JJ's family while removing evidence from her vehicle. The court allowed claims tied to emotional distress caused by aftermath conducted to move forward. Statements by Kaylee, that is the niece, obviously, at 4:30 a.m., Reed allegedly told, maybe I hit him, maybe a plow did it. A lot of maybes again. Negligent distress claim dismissed for Kaylee. She didn't witness JJ's injuries, but the reckless and intentional distress claims survive. And then the public narrative and media, plaintiff alleged Reed helped blogger, journalist, Turtle Boy spread conspiracy theories, harassing witnesses and smear the O'Keefe family. Court found those allegations plausibly extreme and outrageous, reckless intention, emotional distress claims for all plaintiffs, and that is going to be based off discovery if it will go forward. Emotional distress separate from the wrongful death, and again, this is another plaintiff allegations, which is the O'Keefe's. Plaintiff's alleged trauma beyond JJ's death itself, seeing him at the hospital, online harassment, and family disruption. And then you look at the court's ruling on the third. Court reaffirms Massachusetts law. Emotional distress claims are not preempted by wrongful death statute. The parents and brothers distress claims survive. So then we have the conclusion here. We look at the conclusion. Superior Court has allowed the O'Keefe family lawsuit to move forward on nearly all fronts. The decision highlights the involved intersection of criminal investigation, civil accountability, and the impact of online narratives in a high-profile Massachusetts cases. The next phase is discovery and will determine how much of the alleged allegations can be substantiated through evidence and testimony. I'm going to be so curious to see what comes in discovery. Oh boy, I can't wait. All right, let's do this. I want to go back and actually hear what the O'Keefe's attorney is alleging, and we'll hear it, and it was in the document, but I want to play the hearing, and we will listen to what they are claiming in their civil case and what their talking points are. I'm going to turn on closed captions. I'll boost the sound a little bit here. And again, if the first time over here, please make sure to like, share, and subscribe. You can chat here in the chat along with us. I hope you're finding some value in this live show today. If you are, give it a thumbs up. If you want to support the show, you can. Cash App, Venmo, whatever your support is. You can become a member. You can send a super chat, whatever you want to do. It's all up to you. You are the supporters that make this channel run. All right.
I'll read through your briefs a little more closely. Allow us to. Yeah, of course. What I was going to say is that what will happen in just a few moments, I'm going to give the plaintiff an opportunity to respond to that. But I want everyone who's sitting here to understand that the comments I'm making now are not really doing other than just trying to tease out what the issues are. Motions to dismiss are not based upon the evidence, but rather on the allegations that are contained in the complaint. And those allegations, for purposes of a motion to dismiss, have to be accepted as true. And the question is whether or not the plaintiffs have stated a plausible claim under the case law, Iacchino and others that deal with this issue. So with that context, plaintiff, if you want to respond to both the motions to dismiss raised by, I should say, both the two corporate defendants and Ms. Reed.
I do, Your Honor. Thank you. The question that's really posed for this court is, like you just said,
plaintiff's attorney, O'Keefe's attorney here. If this is your first time checking this out and not sure what's going on, that's who we're going to hear from right now.
All facts are true, indulging every inference in the plaintiff's favor. Does the plaintiff's complaint plausibly suggest that plaintiffs are entitled to relief? The answer is yes. This is a motion to dismiss. The lowest standard, the Brum case, plaintiff's obstacle is a minimal hurdle, a relatively light burden, so long as the court looks at the allegations holistically. If relief to the plaintiff is plausible, by the cumulative effect of all the factual allegations pled, we survive the motion to dismiss standard and we move forward to discovery like we should in all cases and in this one. There are three arguments that my brothers have put forward in this case. We oppose all three of them as follows. Number one, the defendants incorrectly state the law by suggesting that NIED claims are subsumed or preempted by the wrongful death statute. Number two, Your Honor, the defendants improperly seek to limit the scope of NIED claims by creating an arbitrary bright-line test for such cases. Number three, Your Honor, the defendants failed to holistically consider the facts alleged and the known vulnerabilities of the plaintiffs when evaluating the defendant's extreme and outrageous conduct in violation of the infliction of emotional distress standard.
And that's talking about the case. That's Aiden's reporting. That's what they're trying to get when they say this, conduct of violating infliction or emotional distress standard on the outrageous and egregiousness. That's the social media aspect of this. This is the reporting aspect of this.
I recognize that this court is not new to this case, and I recognize that most people already understand the facts, but I think it is important and significant that I at least highlight the ones that will be at issue here today. Throughout, we intend, like we did in the complaint, to refer to John O'Keefe.
Real quick, I just want to get to this before I miss it. Jacqueline, thank you so much for the 20 on Cash App. I appreciate the support. I really, really do appreciate that. All right, here we go.
JJ, that is what he was affectionately referred to by his niece and nephew. JJ no longer has a voice. His life was wrongfully taken on January 29th, 2022.
But he does have a voice. And the reason I'm going to say that, and I want to thank Linda for becoming a new member on my Buy Me a Coffee. I appreciate that. Thank you for the support. But he does have a voice. And the voice is Paul. The voice is Peggy. And like I talked about this in the beginning, turn it around. You just sat through 2 criminal trials that literally proved that Karen Read did not do this. She was fully acquitted by a jury of her peers. And you have the opportunity now to turn this around and get the real facts and the information to the case civilly and expose all those at 34 Fairview that night. But instead, they're going to roll with the narrative that Karen Read bad, Karen Read did this, Karen Read killed John O'Keefe, Karen Read. That's the narrative that's going to continue here through this civil case. It's a shame that they won't. Are you blind? Are you blind? That's what I just don't understand. Are you blind to what was just literally spoken of over the last almost 3 years in courtrooms? Are you just choosing to ignore it? Or do you go home at night and you sit together and you go, maybe? I mean, I don't get it. I've shown people and talked to people that didn't know anything about this case. And the minute I started to show just snippets, and I didn't even have to explain it to them, they're like, oh, no, it's weird. Something's wrong. Something seems corrupt. That very thought had not come into your mind at all. I find that very hard to believe. And even sitting there and looking at the text from Proctor, what he was talking about 16 hours in, already made his mind up. All the disparaging things that he said about Karen, violating her civil rights. How do you sit there and say, oh yeah, we're going to roll with them? I don't get it.
He lived a life of service. He was a Boston police officer, and his personal life, when JJ's older sister and brother-in-law tragically passed 2 months apart from each other, leaving 2 young children orphaned, JJ stepped up. He agreed to parent those children, to raise them as his own, and to support them. Fast forward to 2022, Your Honor. JJ is involved in a relationship with Miss Read. It's been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the cold. And Read knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home. There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Read knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost 2 parents tragically. And 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Read decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost 2 parents. After provoking this chaos in the middle of the night, Miss Read leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow, 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries at this point enter into the O'Keefe's consciousness. At around 6 a.m., they rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead. And within minutes of being pronounced dead, that's when the O'Keefe family sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information through him. She pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages are duplicative of the wrongful death statute. We reject that argument.
Yeah, I like that,
JJ's
Heather.
parents are the next of kin, and their emotional distress claims are not preempted by the wrongful death statute. They took their first shot across the bow by making that their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has already pointed out, it patently misstates Massachusetts law. You have pointed out the Cimino case, where, let me just point out first the wrongful death statute. It has two components for damages. It has two buckets of damages. It has the estate's damages. Those all are JJ's damages.
Now, keep in mind, this guy's just a personal injury lawyer. He doesn't give a shit about justice. He doesn't care about finding the truth. It's just going to be all about money to this guy. That's all he cares about. That's all he cares about. All right, let's keep playing.
Suffering the medical bills, things that relate to his damages.
Thank you, Linda.
And then we have the second bucket, the next of kin bucket. Those are lost value damages. The lost value of JJ being in his next of kin's life. And in that case, Your Honor, it is just the parents. Now, they suggest that those are overlapping with the NIED, but Your Honor was right to point out the Cimino case, where a drunk driver kills a 9-year-old boy. The father of that 9-year-old boy brings a case against the drunk and the bar for over-serving him. The father brings two separate causes of action, one for wrongful death, one for NIED, negligent infliction of emotional distress. The court held in that, and I quote, argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress, as the concept has evolved in the Commonwealth, is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct. A claim for damages based on emotional distress, the court says, does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy. It is not preempted by the wrongful death statute. And that's page 334 of the Cimino case, Your Honor. Cimino still remains good law. You were right to point that out. It directly contradicts everything that my brothers just argued here in this court. And I see no reason why this court should overturn the good standing law that exists under the Cimino. We ask that Your Honor deny the motion to dismiss for that first argument. The second argument that they make, Your Honor, is that the plaintiff's NIED claims are not sufficiently contemporaneous with the alleged accident because the family sees JJ 7 hours after the accident. But the law does not endorse such a narrow, arbitrary interpretation of the law. It is misplaced for the defendants to focus arbitrarily on the time of the accident, because let's look at the law itself. The liability for NIED depends on a number of factors: where, when, and how the injury enters into the consciousness of the plaintiffs. And it also requires the degree of relationship between those plaintiffs. But I repeat, where, when, and how the injury enters into their consciousness.
All right, Tammy's asking, we'll just clear this up really quick. She said, I haven't figured out why I'm not getting notifications from LTL Media. What you might have to do, unsubscribe, resubscribe, and then turn on that bell notification. And I always say this as well, too. If you are not getting my notifications, the most important thing to do here, and it's a very, very easy step, and I say this all the time, go and click on this link that I'm going to put in the chat. That is my Facebook group. Click that link, become a member, subscribe. I forget how they do it there. Like the page, and you will get all my notifications. Just keep checking back. I would say at either 8 o'clock in the morning or around 5 o'clock at night, whatever the Eastern Standard Time, that I post pretty regular on Facebook. So you will know when I go live. That's what I would just kind of urge everybody to do. You got to have those bell notifications turned on. YouTube sucks. It's a great platform. We love being here. But as far as their notification system, it absolutely is the dog's balls. It is. I don't know what the fuck they do, how they do it, whatever the algorithm is, but it is dog balls when it comes to notifications. That's why I always tell people, join my Facebook group, join my Facebook page. I post and you will get the notifications, and all you have to do is just check the page, or just come to my homepage on YouTube and check on the front page. You'll see the upcoming live stream, and it will give you the date. All right, let's continue to watch here the bullshit allegations, or what the plaintiffs are saying are facts against Karen Read.
It is misplaced for the defendants to suggest that it matters that plaintiffs were not at the scene of the accident, because, as you pointed out, the Farrader case stands in the exact opposite, where the plaintiff who rushes onto the scene and finds his loved ones injured has no greater entitlement to emotional distress for that shock than a plaintiff who rushes to the hospital.
You know what we call them? We call them ambulance chasers. They're ambulance chasers, Ellie. That's what they do. They're ambulance chasers. They chase ambulance. Ellie says, not all personal injury lawyers are dirty. I swear. A lot have integrity, but this guy is an embarrassment. But a lot of them are. They're just ambulance chasers. But yeah, I mean, listen, they're good attorneys. They're bad attorneys. I get it. But this guy, he's an ambulance chaser. And they got one here. The O'Keefe's got one. This guy doesn't care about justice. He doesn't care about finding what really happened to John. He doesn't really care about getting to the truth. He wants to get the buck from Karen and her team.
So long as the shock follows closely on the heels of. It is misplaced for the defendants also to suggest that there is a bright line test for the number of hours that passes between the time of an accident and when the injury enters into the consciousness of the plaintiffs. Your Honor has persuasive authority from the Zachary case that shows that an NIED case can survive even when the close family doesn't see the deceased body or the injured body until a day later after the wrongdoing. There is no bright line test. NIED is a fact-intensive analysis. And when we apply the law to the facts of this case, let's look at where, when, and how the injury enters into the consciousness of the people that we're bringing those cases for.
And it goes to this too. And we just watched the Billy Bush interview with Alan Jackson. And he said, there's cases that come across your desk. You either take them or you don't take them. And that's based on your morals. If you think it's wrong or right, any lawyer would have passed on this, I think. Unless they just want a buck, unless they want to make up, try to get a buck out of this. And I agree, Debbie, lawyer, no, very upstanding lawyer. I love his breakdown of all these cases. I love the interjection. I love his commentary over this. And she says, yeah, but I agree that definitely some are ambulance chasers. Absolutely. But like Alan Jackson said, if he was a prosecutor, he would not have taken this case, and he would have dismissed it. He would have dismissed the case against Karen Read. There is no case. All right, here we go.
It's 12:30 a.m. and nobody except Karen Read knows about JJ's injuries. Defendant's wrongdoing continues into those early hours. She knows she struck him. She seeks no medical help. Instead, she chooses to cover it up and hides the injuries from anyone. It's not until 6 a.m. that JJ's injuries are even capable of getting into anyone's consciousness. The O'Keefe family immediately learns of JJ's injury, and they closely on the heels, they rush to the hospital, at which time they see the deceased body within minutes of him being declared dead. It is incredulous to think that a wrongdoer who hides the wrongdoing and the injury from anybody can be relieved of liability simply because the injury becomes knowable only after they disclose it. The defendant's cited cases are inapposite. They have no relationship to what is being asked of this court. They all involve a motion for summary judgment standard, which is a very different standard than the one that we are talking about here today, the motion to dismiss, the lowest hurdle to overcome. They try to equate it to a mother who learns of the rape of her daughter 7 months later, but that rape was known to other people within days. They try to relate it to the Migliore case, which has no relevance because it deals with somebody who has no close relationship. They didn't even know the decedent, and therefore it doesn't meet that standard. And then they rely on the Cohen case, which I heard both sides try to suggest has relevance. But in that case, Your Honor, the mother learns of her son's death 7 hours after the death. That's 7 hours after the injury occurred. And by the way, it was already knowable 7 hours earlier by other people when that plane crash was projected, and the son of the woman who brought the claim knew about her own, his brother's death. The mother is 1,000 miles away, so spatial proximity is not there, and she only learns of it via phone. Does not experience the injury and never sees the body. Contrast that with everything that we talked about, Your Honor, where as soon as it was knowable, they learned about it.
You know, Ellie, I'm going to give you my opinion about that. No, I don't. I think he's smiling, and we've seen him smile. We've seen him smile when they do the audience shot here. Smiling. I really don't. I in my opinion, I don't. He wouldn't be going through this. They would turn the tables. They would turn the tables. I'm just beyond all of this. 2 criminal trials, all the evidence that was put in front of your face, and you're literally going to sit there and say, yep, everybody there at 34 Fairview, they're super credible. I believe everything they say. They have nothing to do with this. Mass State Police didn't fabricate any evidence. Tully, Proctor, and Buchanan, they're good guys. They did the right thing. Canton Police were solid. They were there. They did everything the correct way. First responders, whatever it may be. Chloe. Those are the people you want to roll with. Don't get it. Don't get it. You had the opportunity to turn this around. Get to the truth. All right, here we go.
They rushed to the hospital, they saw the body, and they saw the body within minutes of him being declared dead. The purpose of the law is to distinguish between emotional distress from perceiving an injury versus the expected anguish that any person would feel from the death of a loved one. I want to talk briefly about Kaylee and her NIED claim to suggest because she wasn't at the scene or because she was not at the hospital that day and they tried to spare her of that does not suggest she doesn't have a right. In fact, she experiences the trauma, the panic, the chaos of the injury contemporaneous with Karen Reed waking her up in the middle of the night and exclaiming that her parental figure, the third that she has now lost, was dead, hit by a plow or her SUV. Notably, this enters into her consciousness before anyone other than the wrongdoer knows of the injury. To the extent that defendant seeks relief because Kaylee did not see with her own 2 eyes, I refer you also to the Cohen case, which they cite for different reasons, but in it the language talks about sensory perceptions. To suggest that you can't use other senses in order to perceive and experience the injury or the injurious event is wrong. Otherwise, no blind person would have a legal right under NIED. We have many senses. We use them all the time. And when it enters into our consciousness, it's hard to undo of it. It is very different from learning that your close family member has died. That is upsetting. It will be upsetting to anybody. But to have experienced the event or the injury and enters into your consciousness, that is the very reason and the foundation why NIED exists as a claim. So on that second, we also suggest that you should deny it because the experience the injuries closely on the heels of them being knowable and perceivable to anybody. Third, Your Honor, the defendants argue that the intentional/reckless infliction of emotional distress claim should fail because there's no extreme or outrageous conduct directed towards the plaintiff. But when viewed holistically, the facts demonstrate that Ms. Reed should have known her extreme and outrageous conduct would be detrimental to these vulnerable.
And that's what they're talking about when you hear that, the extreme and outrageous conduct. That's the whole social media part of this. This is the whole, allowing a journalist to create and tell a story, to tell this story about what happened from Karen's side. They can do that. Journalists do this all the time. There's stuff that's given to journalists to write articles and talk about what's going on. That's the First Amendment, freedom of press. And they're trying to say this is outrageous conduct, that it caused all this emotional distress. Well, then, why are they not suing every fucking newspaper or every program or every major mainstream media outlet that talked about this case and had panelist guests on there and gave opinions? Court TV, where they had opposing and for arguments on there. For fucking almost 3 years, they did panels. Why are those people not getting pulled into this? It's because they're trying to keep establishing this fucking connection between Aiden and Karen. And all it was a journalist that wrote stories and brought out the truth as to what happened to Karen. That's it. All right, here we go.
Plaintiffs. And I use the word vulnerable plaintiffs because it's relevant to our case law, Your Honor. It's misplaced to suggest that the conduct needs to be directed immediately towards those plaintiffs. As long as she should have known that the emotional distress was the likely result of her conduct, that's sufficient under the reckless infliction of emotional distress standard. So how do we evaluate what is extreme and outrageous? It's fact intensive, but the law does recognize that some critically important factors that need to be considered when evaluating what is extreme and outrageous. Plaintiff's susceptibility, defendant's knowledge of that susceptibility, and the relationship between defendant and plaintiff. The case law all suggests that gives rise to extreme and outrageous conduct. In evaluating whether defendant's conduct was extreme and outrageous, the courts should consider whether individuals at whom conduct is directed is known to be particularly susceptible to infliction of emotional distress. Boyle versus Wenck, 1979 case we cited to, Your Honor. Our case law has recognized susceptibilities to evaluate extreme and outrageous conduct to be a recent hospitalization in the Boyle case, a cancer patient in the Harrison case, elderly or frail people in the Bailey case, or children, minors, based on their age in the Sarkonis case, all that we've cited to, Your Honor, and I'm happy to give you cites. The law in Roman versus Trustees of Tufts College says, as it relates to this, the court should put as harsh a face on the defendant's actions as the basic facts would reasonably allow. The relationship of a plaintiff to the defendant and her knowledge.
This shot's a little weird. I don't know why the hell this camera guy focused on the hands and then did this kind of like up shot of Karen. Oh, weird.
Of the plaintiff's sensitivities is an important consideration in determining whether the challenged conduct satisfies the extreme and outrageous conduct. That's the Russell case. Let's talk about Kaylee as it relates to the infliction of emotional distress. Should defendant Karen Read have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Those are the questions that ultimately we pose to a jury. Kaylee was young, 14 years old. The defendant had a relationship with her, knew she was emotionally fragile, knew she was orphaned at the age of 6, knew that she lost both parents tragically. The defendant assumed this pseudo-parental role with Kaylee for nearly up to 2 years. The defendant, Ms. Reed, knows that she knocked JJ down. It's the middle of the night. She wakes up Kaylee abruptly. She talks about JJ being dead, being struck by a plow, being struck by a vehicle.
Did he say, I want to go back here? Let's listen to this. All right, let's hear this again.
Young, 14 years old. The defendant had a relationship with her, knew she was emotionally fragile, knew she was orphaned at the age of 6, knew that she lost both parents tragically. The defendant assumed this pseudo-parental role with Kaylee for nearly up to 2 years. The defendant, Ms. Reed, knows that she knocked JJ down. It's the middle of the night. She wakes up Kaylee abruptly. She talks about JJ being dead, being struck by a plow, being struck by a vehicle. Mind you, this is all hours before anybody has even discovered his body, and she is now actively talking about him being dead. Then, after creating this chaotic, upsetting situation in this young, fragile girl's psyche, she leaves her. She leaves her home alone, shocked and frightened. Compound that by defendant's choice to speak her false narrative publicly, to use social media, to leak public information through Turtle Boy, to control that narrative. Why is Turtle Boy out there saying the O'Keefe's family period of grief has expired and they are now fair game? Who leaked the autopsy photos that got published by Turtle Boy for this vulnerable family to have to be exposed to that they weren't seeing before? To the extent that the defendant argues that this is not extreme and outrageous, remember the law. It is the jury's role to decide whether the defendant's conduct was rude and clumsy or extreme and outrageous. That comes right from the case law. As it relates to the family, Your Honor, should the defendant, Karen Reed, have known that emotional distress was the likely result of her conduct? Was defendant's conduct extremely outrageous? Again, those are the questions posed for a jury ultimately. But the law says conduct.
Yeah, and I mean that's the thing that a jury's going to have to decide in this is that is that really what people think about in situations? Like I think this is going to be super hard to prove. I'm sorry, and I'm trying not to be like biased here, but I'm just listening to this. I'm like, how can you exactly prove? Like they're acting like Karen sat there and she has like this big black mustache and she's twisting it and she's just methodically twisting it and all this stuff is at the forefront of her mind in a very tragic situation. That's what the O'Keefes are trying to say, that Karen just sat here and went, "Mwah, mwah, I'm going to damage this family. I'm going to do all this emotional distress and cause these things." I really don't think that any of this is at anybody's forefront of their mind when they're in a situation like this, especially when you didn't do anything, when you were absolutely cleared of all of these bogus charges in 2 criminal cases. So how do you put that into the frame of mind if your frame of mind really wasn't that and you're trying to portray that your frame of mind was that from the O'Keefe's angle? I don't know. I don't get it. It's insane. How are they going to prove this? I think the jury's just going to laugh at this. All right, here we go.
Which the actor should have known would result in distress is actionable. And the plausibility standard, the motion to dismiss standard, which is where we're at right now, Your Honor, simply calls for enough facts to raise a reasonable expectation that discovery will reveal evidence of the illegal conduct. Margaret and John have now buried 2 children. Paul has buried all his siblings. Defendant always knew this. She has always known their vulnerability, and yet she creates a calculated and malicious campaign of disinformation designed to hide the truth in this case. She pits the O'Keefe family versus the Reed family, and a reporter who she asserts editorial control publicly proclaims to Reed supporters, the O'Keefe family's period of grief has expired and they are now fair game. Discovery will track how much leaked information defendant should have known would result in distress to the O'Keefe family.
Point here by Listless just says, hey, any reasonable person would have the same reaction as any of us. You just can't go around and sue everybody when someone dies. That's a great point. And I agree. I super agree. All right, here we go.
To the extent that the defendant suggests that this case fits nicely within any other case decided on this issue, remember the facts and circumstances here are exceptional. We wouldn't have these TV cameras or a full courthouse if they weren't exceptional. That is why we are here, Your Honor. It doesn't fit within a nice box like every one of those cases I cite. The Polay case where we talked about false police reports and harassment petitions were not considered towards emotional distress because they were petitioning activity.
One of her
talk about
attorneys.
that briefly, because what Ms. Reed has done is not petitioning activity. It is not asserting a defense within a courthouse or having her legal counsel assert that defense or testifying at a court hearing. Instead, what Karen Reed is doing is not petitioning at all. She is waiving her Fifth Amendment privilege. She's speaking anywhere and everywhere that would give her a friendly audience with editorial control. She's gone on Dateline, Nightline, 2020, Fox 25, Boston Magazine, Vanity Fair, WEEI, Turtle Boy, HBO Max, ID Discovery, etc. There are more.
She never went on Aiden's show. I don't know where he got that. She never went on Aiden's show. She never physically went on Aiden's show. Where'd he get that from?
This is an exceptional case that requires exceptional discovery, that requires us to decide this matter by a jury, not by a motion to dismiss phase, Your Honor. It is not like the Quinn case that they cite where there's an open adulterer involved, and so they think that's not extreme and outrageous. And it's not extreme and outrageous like it has nothing to do with the employment case where they fired somebody who had a criminal case pending and they brought them back on, and he didn't like the way that they treated him after he was found not guilty, which is different, by the way, than innocent. The court should deny the third of those arguments. They should know that plaintiff's susceptibility and vulnerability are at issue in this case and are the very reason and foundation why it is extreme and outrageous conduct, and that defendants' improper actions would cause severe emotional distress. Defendants' actions were not rude and clumsy. They were extreme and outrageous. We ask Your Honor to allow this case to go forward with discovery, allow us to explore each and every one of those issues.
Oh, please do. I want to see it all. Please do. I want to see the phones. I want to see the communications. I want to see the documents. I want to see the photos. I want to see the video. I want to see everything. And you will get it in a civil trial. So this is where I always said over the last couple of streams that I've done about this civil case, are you ready? I asked that question. Are you ready? O'Keefe's. Are you ready, McAlbert's? Are you ready, MSP? Are you ready, Canton Police? Are you ready, first responders? Let's go. Because it's all going to be on the table now.
These are real damages for real people who have suffered long enough. Thank you.
Thank you. Any response from the defense?
Your Honor, briefly. Firstly, those allegations contained in a complaint are allegations which we will refute. Counsel cites to the Camino case, relies heavily on it. What counsel didn't tell the court is that in the Camino case, the father of the child who died in the car accident was himself hit, part of the car accident. Gets up, runs to see his son. It's contemporaneous. It's at the time of the event. And the court didn't have the same spatial, relational, and temporal concerns that the cases speak to with respect to emotional distress claims. So I point that out for the Your Honor. He also mentioned much about conspiracy theories, much about going out in the public and creating a narrative, which is precisely the reason why we're going to brief the issue about why those other parties need to be in this case. As I'd said, it is more than just a wrongful death action, Your Honor. I respect the opportunity to brief that, and we rely on our papers and defer to the court on the motion to dismiss.
All right, thank you. Any other defendants wish to be heard on the issue? Motion? Anything else? All right, thank you. Certainly, there's a lot to the complaint, and again, for the record, so that people understand this is a pre-discovery form of relief that the defendants have sought by way of dismissing certain of the counts that are in this complaint, and the court has to consider the allegations as being truthful and every reasonable inference to be drawn in support of that. So I will look forward to reviewing that. I'll issue a decision as soon as I can. As expected, the lawyers in this case have advocated the positions of their clients very clearly, and I expect that with the procedural things that might be asked for at some point, that this case will have a very long tail to it as it goes through the litigation process. We expect that.
It's going to be a very complex case. I'm not going to finish out what the judge is saying here, but basically, how he's going to wrap it up is it's going to be a very long, convoluted case. It really is, and this is why I said, even Nan was up here the other day, and Todd was like at least 2 to 3 years, probably more. I was watching Lawyer this morning, and he was talking about the recent motion and going through it, and he said it could be more. This could be years. There's just so many people involved, so many angles involved, so many filings to go through, depositions, evidence collection. I mean, if you think the criminal trials were a thing, oh God, civil trials are insane. Absolutely insane. And then we were hearing 2027. This actually could see the light of the day in a courtroom. So crazy. But, again, I just wanted to pop up here, talk about this, one of the motions that were dismissed, but it is, this case will go on. And I think that the lawyers are going to continue to battle behind the scenes. They're going to put in their motions. They're going to challenge things inside the civil case, and we'll have to see, what comes out of it. So Queen of Hearts says, hey, this case is going to be a chess match. I totally agree. Before we go, I just want to do this. I got a PayPal from Lisa. Thank you. She says, your presentations are incredibly helpful. Thanks for all that you do and the work to finding justice for John O'Keefe. You know, that's what we try to do here, and still cover the Karen Read case as much as we can. When new information comes out or anything that's pertaining to her cases, we'll talk about it here. Lettuce is saying the next hearing will be on November 21st, and that is going to be the next hearing. So again, you know, we cover different things here. We talk about different things. There may be cases that you're interested here on this channel. They may be not. On Tuesday night, Wednesday night, we usually do our Monday night with Todd and Nan. They're going to be on Wednesday. Nan's traveling right now. But we're going to start talking about the Brian Walsh case. And I hope that you all will come in and join us. We're going to do a basic breakdown of that case, things to look forward to, things that will be challenged. Is the Proctor angle anything to worry about? We'll tackle all of that. I can't wait to see what they both have to say about it. And I have a nice presentation that we're going to do in that too. So again, and yes, Morrissey can be questioned in the civil case. Absolutely. And thank you. Thanks for watching. I appreciate it. And checking out. So again, if this is your first time over here on the channel, please make sure to like, share, and subscribe. We'll keep talking about these things and you know, giving it attention as needed on an as needed basis. And there'll be other trials and things that we cover here. And I hope that you come over and watch what we do here. Great chat tonight. I'm glad that everybody participated, and thank you for all the support. Again, we had a couple new members. Quiz, thank you for becoming a new member. I appreciate. We had the super chat from Golden Mom, $5. I appreciate that. Teresa became a new member, and Linda Mitchell became a new member as well. I know I owe you all a members only pretty soon, and that's, you know, that's pretty cool. When we do those, it's just more relaxed. You get to do a lot of Q&A, ask me questions of what's, you know, what you'd like to hear about or talk about. We can do that. So thank you chat. You're all great. I'm not sure if I'm going to do anything tomorrow. If something pops up, maybe I'll do a small live stream. I don't know. Usually I do stream on Sundays, but I felt like doing Saturday night to possibly just keep my Sunday open. I mean, I don't know. Maybe I'll do a stream tomorrow. Not too sure, but thank you all for being here. Thank you. I know a lot of people have been asking about this, and I'm just going to answer this. My lease ran out. I was in the active of going to re-up my lease, and I decided not to. I wanted to come back home, and I'll be honest with you all. The reason I wanted to do this was because over the last 2 years, I ran hard. I mean, I was doing 3 to 4 shows a week. I work 40 plus hours a week. I have a regular job besides YouTube. And then on top of that, in between, my life just became searching and researching and putting material together for shows. And we had the grind of the trial, and we had the grind of the hearings. And I'll be honest with you, I lost touch with my life, my personal life outside of YouTube. And I needed to reground myself and find who I was as Brian offline. There were many things that I needed to attend to here in my home that I was dismissing for like 2 years. And I lost touch with personal relationships, and I lost touch with like friends and my family I lost touch with. And I'm like, I need to like bring this back down again and get home. And I just was not spending any time at home. There was many things that I wanted to do here in my home and fix and attend to. And this time has allowed me to do that. You know, I took a little bit of a break. I worked on some things. I have some new furniture in my house. And I always say, like, your home environment has to be in check before you can do other things in life. And I needed to do that. So yeah, I came back right from where I started. We kind of dressed it up a little bit here in the corner of the bedroom. And I'm back home. And, you know, this was a better viable option for me, you know, to get back in touch with my family, to attend to things, to tend to personal things, to, you know, get back to relationships with my friends and my family, attend to health things that I've needed to do, and just all those other things, and mental health. And I'm very strong on that. I have no qualms about that. I see a therapist on a regular basis. I think everybody should see a therapist if you have the means to do that, or if you just even have someone that you need to talk to. Please do that. Please do that. In 2011, my brother took his life on October 8th. Will be, I don't like to say anniversary, but I urge everybody to get mental health and be part of that. It should be part of your life. If you don't have that, have a friend to talk to. There's always someone to talk to. There is always someone to talk to out there. But anyway, and I don't want to get off target here. But yeah, that's basically what I did. And it felt good to just come back home and be able to do this and just, get my feet grounded again, work on things here at home, my health, and stuff like that. So, but that's going to be it. Thank you so much for being here. I appreciate you all being here. And please like, share, and subscribe. Comment down below after the stream is over. I appreciate it. And my next stream is scheduled for Wednesday night at 7 p.m. If I pop in and do something in between that, maybe you get the notification. You can come out and hang out. We'll just see what happens over the next couple of days. So I see a lot of positive comments here. I appreciate it. Tammy says, look, she goes, I'll be honest with you. I think we 3 years of our lives, she did, it just was getting a little over consuming. And sometimes you kind of lose yourself and all that. And you're going to reground yourself and find out like, hey, I'm another person offline, and you need to do that. So again, I always urge someone, please talk to someone. If you have regular therapy in your life, do that. There's nothing shameful about that. I had a situation that happened a couple of years ago, and the person turned to me and said, maybe you need to talk to someone. And I took that instantly as advice from my God through that person. And I went and did that. And it's been one of the most healthiest things that I have done in years. And, I urge everybody, please get therapy. So, yeah, Lauren says I talked to her and talks to her in his therapy. I always do. Yeah. Lauren's like my BFF offline. I love Lauren. She's been there. And actually our friend anniversary happened the other day, and the first time that Lauren was on my show. So, anyway, it's really, really good. Thank you, Linda. I appreciate that. I appreciate all the support. I appreciate all the positivity, and we'll talk to everybody soon. All right, I'm going to head out, hit the outro. Everybody have a great rest of their Saturday. Tomorrow's going to be great. Sunday here in the Massachusetts area. Get out, enjoy that weather, get some sunshine, some vitamin D, whatever you need. Pumpkin spice, carve your jack-o'-lanterns. Let's see it. I'll talk to everybody soon. Take care. Bye-bye.